legal. He has vast experience. He assists clients in obtaining trademarks, patents, copyrights, and industrial design rights globally. Very warm welcome, Mr. Ganapati. And the last speaker for this session is going to be Mr. Vihan Dang, Associate Partner, Mason & Associates. He's a practicing advocate and registered patent agent, excels in IP law, representing film, music, seed, and technology companies. So I'd request all of you to kindly be seated, and those who want to probably have a discussion can maybe do it after this session, or probably move to the tea area so that we can have a good discussion here. And without wasting any more time, I'd request the moderator for this session, Mr. M.S. Bharath, to please begin the program. And I request all of you kindly be seated, sir. Ladies and gentlemen, kindly be seated. This session is beginning in 2 seconds. Thank you.
Very good afternoon. It's quite a difficult panel to have one immediately before lunch, because we understand that it's already lunchtime and some of us may have had an early breakfast. We'll keep it as short and light as possible, though it's heavy-duty subject matter and we have a new law which came out in August of 2023. Earlier, when we were discussing about half an hour back on the subject matter, we kind of realized what exactly the topic would be, with globally India catching up with the GDPR. And if you go back in history, India has been very, very protective about privacy, but in more of equity. We didn't have a statute back in the time. And the first ever really large-scale litigation which set the tone for privacy in the country is the Puttuswamy case. We had really 9 Supreme Court judges setting down and confirming that privacy is a fundamental right under the Constitution. So it's a very well-written, long-drawn jurisprudence which set the tone, which was eventually followed by the B.N. Sri Krishna committee report. If some of you have possibly read that, it's also quite detailed, which became the basis of the DPDP, as in the Digital Personal Data Protection Act, to come out. So, shortly put, we are not here about data, we are not about personal data, we are talking about digital personal data. The DPDP Act is very specific, not all data are covered by it. It is going to be digital personal data. So it can possibly travel with you right from birth. You get a birth certificate, you go to school. In school, you are given all your personal data. From there, you collect your personal data and give it to college. From college, you go to graduation. And graduation, wherever you are admitted to a hospital or for a health checkup, all your personal data is taken. And until now, we've been badgered with unsolicited calls, with those phone numbers, whether we need insurance, whether we need any product to be sold, direct marketing calls. But I'll pause there and say that in the days to come, we are expecting the set of rules, which might be 20 or 25 different set of rules under the DPDP Act. With me are an eclectic set of lawyers who've had tremendous experience in intellectual property, more so on data. Immediately towards my left is Puja, who comes with 20 years plus experience. She's a partner, commercial contracts in LexOrbis, a leading firm in the country. And so is Vihan, who is from Mason Associates. My fellow lawyer from Madras Bar is Ramesh. Nashish and I started our career together probably a quarter century earlier. So I won't waste much time between you and lunch. We can start off with Ms. Puja to set the tone and tell us her brief experience and also how she would like to talk about consent and audit, which possibly corporates need, and how consent is the ground and the basis for implementing the DPDP Act. Over to you, Puja.
Hello everybody, very warm welcome. And as you are aware, the rules have not yet been notified for the DPDP Act, which came out in August 2023. So a lot of things will perhaps be more clear once the rules are notified. But having said that, we have, going by the reading of the DPDP Act, it is clear that the companies have to be more discreet about the usage to which the data is being put. So the most important aspect that just Bharath highlighted was these unsolicited calls that we get. So there is data which is freely floating around. Nobody knows who all have access to it, on what basis it is being given. And once this consent clause, which has been included in the Act, comes into effect, it will have a repercussion on companies, because Indian companies as on date are not used to capturing consent. How you capture consent, how you take consent, and how you allow the party to withdraw consent. Second thing which is important there is what is the purpose for which consent has been given. So if to a telecom company I am sharing my data to get a mobile number, the consent is limited to that purpose. It should not be floating around and being shared with other telemarketers or other group companies within the group who think they have access to those data sheets and they can use it for marketing. So these are aspects that have to be kept in mind. A very critical aspect which will come into force will be consent on behalf of minors. Because there again you have to show consent has been actually taken from the guardian, and the consent was given freely after understanding what the consent was being sought. It should not be that the arrangement is such that even children are clicking on it and the consent is being given without the guardian even getting to know about it. So that these are aspects which, when implemented, when the rules come out, perhaps there may be some guidelines in that, but these are aspects which have to be implemented by all companies, because frankly speaking, there is no company today which is not in the digital space. So e-commerce and digital media have now changed the nature of business to such an extent that all companies, whichever product they are dealing in, have to be mindful of these aspects. And another important point which companies, software companies have been adhering to GDPR. So for them, it is nothing perhaps new which will happen. The rules may be similar. But Indian companies, Indian entities which are more into FMCG space or homegrown companies may not be aware of even the places where they need to check their data points. So an audit may be required. I'll give a very simple example of, say, the way earlier entrance at any company, there used to be registers where you just sign in and you enter. So that data would not be in a digitized form. Now everywhere you go, there'll be a computer, they will make entries, they will issue a digital pass to you, maybe some message will come on your phone, you will share an OTP. So some kind of record is being connected, some information is being collated at their end, for which they are not even aware that what is happening to that data, whether that data is being secured properly. And these are all aspects of personal information by which I can be personally, or anybody can be personally identified. So these are points where a focus is needed, and a roadmap has to be made for all companies to have an audit, see what they can do about these data which is being collected, how much of it is actually necessary, whether the extent to which the data is being collected and stored, is it even required to that extent. So these, I can go on, but I think I'll give a chance to others on the panel.
Thanks, Puja. That's very important. Firstly, to know what you have, in the sense, what kind of data do we have at home? So it's important that every corporation does an internal audit. If you are a corporation or even an independent small SME or MSME or small micro, size doesn't really matter, because there is no difference in compliance whether you are small, medium or large enterprise, except that under the statute we need to understand that there are about 5 different players. One is data principal, as in whose data we are talking about. The data fiduciary, the entity or individual who collects the data. And then there are processors who churn the data out and give it back. And then there are consent managers. And of course, you have enforcement part of the tribunal as well. Having said that, it's interesting that you talked about consent and audit, and especially in terms of minor as a take-home point. 2 days back, I was coming into Delhi, and we have this Digi Yatra app. And there is an interesting article in the news that the CRPF personnel who are standing there, they sign you up for Digi Yatra without even asking your consent, that they are taking a picture and making you confirm that they are okay. But they are pushing Digi Yatra, that's okay because that's decongesting the airports. But where is the consent? What kind of consent? Is it valid consent? And we will get to that in a bit, but I will move on to Vihan, who wanted to touch upon how these large set of data are moving between territories and geographies, and how that would possibly have implication on movement of data and enforceability as well.
Thank you so much. Hello everyone. So just in terms of the concept of cross-border data flows, I mean, we're looking at what are the IP implications around data protection and privacy. So data is a core and a critical aspect of all IP. So how does the Digital Personal Data Protection Act look at this core principle? So essentially there are two aspects. So when we talk about cross-border data flow, how is data transferred from our territory to outside any other territory, and what are the guiding principles for that? So here, of course, I think all the panelists have mentioned a lot of clarity will come in with the rules, but the framework essentially followed in the Act is that it seems to be a blacklisting system. So what that means is the central government can notify ABC countries or territories as territories which are restricted countries for the purposes of transfer of data from India to those countries. So the next logical question is, what are the parameters? Are we looking at, are we looking at a situation where, there is a country with whom we do not have great relations, so therefore it is on a blacklist? Or are we looking at specific parameters based on our learnings from, privacy laws around the world, GDPR, and the guiding principles which go into privacy laws, such as Europe has a concept of an adequacy determination, that whether Europe will decide that this country is safe because it gives you adequate protection for personal data. So the sense here seems to be that it is a blacklist. What are the criteria which will go into the blacklist? We'll have to see from the rules. But I would hope and expect that there will be fair delineation of the actual parameters which go into identifying or placing a country in the blacklist or a jurisdiction in a blacklist. The other aspect to that is, what about sectoral specific regulations which are more stringent? So you have the core principle that there will be a list, which is, if you're on the list, the data can't be transferred to, XYZ jurisdictions. But what about sectors such as finance, payments data, or medical data? So there, our legislative framework under the Act has basically set out that if there is any regulation which is more stringent than the blacklisting criteria. So, for example, a payments data or a UPI-based payment system which will be governed by the RBI and the NPCI framework. So, if there is a more stringent sectoral regulation, that will continue to apply. So, thereby sort of achieving a balance that existing regulations or restrictions on data transfer, which are in line with the data which they are regulating, they propose to regulate, and the object of that data, those will continue to remain. So in that sense, that is the balance that the statute endeavors to achieve. And essentially, that's how cross-border data flow is being looked at. Of course, I think with the rules, we'll have more clarity on the exact parameters, as I mentioned.
Thanks, Vihan. That reminds me that we should go to Lakshadweep and not Maldives. For all you know. what's going on in the social media these days. But having said that, I take it because what Vihan was mentioning is about a specific set of sectoral data, but that's what is precisely called as personal sensitive data. There are sets of data, there are sets of personal data. Within the personal data, there are sensitive personal data, which is your health records and financial records. I don't want to know that I'm going to be under liquidation and or filing for bankruptcy. I don't want my neighbor to know that. Moving on to Ramesh, if you can touch upon how corporations are to look at framing policies internally, externally. Why don't you tell us as to what you would like to touch upon on the policy level?
Good morning, everyone. So, I would talk about the data protection as well as the IP implications on the corporates. So, there are various data when it comes to the companies. It's about the functionalities as well as the assets of the companies in the form of data. So, for example, if you are a company running an R&D, a pharma company or a manufacturing company. So in the R&D, we come up with various researches, and there are raw data which are being stored and we have been identifying. So before getting into these filing of patents or other things, data are not just data, and some of the data are IP. You can protect those data only by filing IP applications, for example, filing a patent application or a design application, or sometimes copyright protection for the literary data. There are various forms of data in a company that can be in the form of databases, the compilation of databases, and personal details of employees, financial details of the companies, and as I said, the research-oriented details in R&D. Sometimes, if the institutions are educational institutions, even their study materials are in the form of data, and they definitely are entitled for an IP protection by way of copyright. So these are the ways in which you can protect your data, that will turn into IP by protecting an IP. Sometimes even not only by getting an IP protections, we can also protect our data before going for an IP by getting into a concrete agreement like NDA, non-disclosure agreement. And sometimes you want to have a collaboration, or you find in investors, they have a business talks. In the initial stage itself, you share a lot of information and data to the investors and the two companies. So without having a proper NDA, and if the data, what you are sharing to the investors, and if there are crucial data and it has some financial or technical data, and definitely there are chances that it may be misused. So there even you can get into an NDA, strong NDA, for protecting your data if there is a violation in future. So similarly, so there are, I would say that, prioritizing your sensitizing the data of the company is the priority. First, you can do identify or prioritize your sensitive data in a company. Like I said, the IPs are other things. And number two, if there are innovations in the company, and you can go for a design protections or a patent protections, the data which are revolving around the R&D or in the process. And you can do a compliances with the laws, regulating authorities. And sometimes, if the company is having a proper data protections combined with IP protections, the competitors and investors will have a trust on the company that the company's data are protected. So these are the ways you can protect your company data. So when we talk about these data of the companies, how to protect over the IP implications. So I can give a current scenario and actual scenario, what is happening in IP offices. See, we all file trademark applications, and when we file a user affidavit, so along with user affidavit, we file a lot of invoices and the annual turnovers you just mentioned. Earlier, if you see that, even the email address of agents and phone numbers were visible. Now they are at least redacting. But still, IP offices, when you upload the invoices and the annual turnover figures in the user affidavit, everything is uploaded. It's not necessary that everybody can see the company data, my personal, sensitive data are being shared everywhere. So I think that kind of there should be a strict measures to be followed by IP officers as well when it comes to the company's sensitive data. So these are the areas we need to look at and need to take some measures.
Thank you, Ramesh. I think the IP offices have also to be compliant with the DPDP, if in case there are, of course, personal data and digitized personal data. Interestingly, if any one of you are part of the International Trademark Association or INTA, there is a separate committee which is for data protection, and that committee has done a 2-year study and presented a white paper on why data is an intellectual property asset. So it's freely available. Go to the INTA website and please do read it. It's a very interesting 45-50 page report which will say why data is an IP, and that takes us to Ashish, who would possibly touch upon why and how IP is touching upon data and why licensing is important.
Okay, Ramesh has touched something about IP. But I think let's go down to the basics. What is IP? You have trademarks, you have copyright, patents, geographical indication, designs. When you try to fit data in any of them, it doesn't seem right, except when you come to copyright. There is this compilation of records that you can actually protect. Now, apart from that, I think what one needs to also understand is how you manage that data. So the computer program that you actually develop to kind of create some algorithm or something, some kind of a table, which again is protectable. So that's also is protectable. But if you come to patents, designs and others, those you would see it's everything that has been revealed. It doesn't come within actually that ambit. But there's a certain aspect which is, obviously we don't have a legislation in India which is called trade secrets. Like for instance, as being from a law firm, I would say maybe most of our colleagues here from the same fraternity would be your client list. That's your trade secret. That's something which is confidential to you. It's related to you. Now, again, there is no statute per se, but again, we obviously have issues relating to trade secrets in India. So how do you protect it? Now, we don't say that trade secret is not intellectual property, do we? We say it is. It is part of an information that is very important to an organization or to a company to perform or excel or monopolize certain things. So from that perspective, you look at it. In terms of my understanding is that it would come under the copyright. Obviously, you have a certain program, you have a certain table, provided it meets that benchmark of being original and it kind of create creativity. At the same time, on the trademark, on the trade secret angle, I do believe it is protectable, obviously through contracts in India as of now. We don't know what will happen a few years later, but as of today, as it stands, do through contract. So from my perspective, this is how there is this interplay between the IP and data.
Thanks, Ashish. Interestingly, we are always asked to compare how the Indian Data Protection DPDP Act is faring with GDPR. The biggest differentiator is the consent, and the biggest differentiator is the consent manager. While GDPR lets it to private players and possibly mobile applications developed by private corporations, it's not still clear. I'll probably ask Puja, who's a better expert. Who is the consent manager and what is the nature of consent possibly? Because if at all consent managers are going to be a government agency or if it's going to be a private agency, like I hear some of my colleagues who went to Germany and came back, they say that there is a separate app which will control your consent for all the other apps. So it will be a consent app for all other apps of what kind of data of mine will go there. So Puja, if you can touch upon nature of consent and what you visualize consent manager's role would be.
I mean, this is still conjecture because till the rules don't really get notified, we do not really know which direction it will take. But the way the DPDP Act is worded, it appears that the party who is collecting the data will have the responsibility of taking consent. Because if you collect the data without consent and you kind of shift that responsibility to somebody else, then there will be always a time gap and there's a possibility of the data being used without consent, which is what this act wants to regulate. So first and foremost, there will be a point of consent at the time of data collection so that the purpose for which the data is being collected is recorded and the company or the entity who is collecting the data has to honor the consent parameter for which it has been collected rather than using it for other different purposes as well. Having said that, there will be a monitoring mechanism. There can be a common consent manager kind of an entity for a group of companies or for industry or whichever way the government defines it. But all these are things which we will get to know only once the rules are shared.
So rules it is. I think the Information Technology Act has got some 25-30 rules and regulations and updates and notifications, which even a full-time IT Act professional is very hard to fathom. I'm sure DPDP Act would have a separate department internally in corporations and possibly with large law firms as well. I'm told that the Act requires all the policies to be in 22 different languages. We'll come to that on a different day. So possibly we have to hire translators to...
The Bhashini app is what the government is trying to emphasize whenever they speak about so many different languages because that's the latest breakthrough they have had.
Correct. So that takes us to the enforcement part. If Vihan, if you can come in and say in past possibly jurisprudence, and I would ask possibly Ramesh and Ashish to also chip in as to what has happened thus far and what do you visualize in the times to come on possible individuals complaining against errant corporations or two corporations fighting over data sets. But I just want a very high level perspective because we just have the vehicle, we don't have the fuel. What I mean by that is we have the act but not the rules. So Vihan, Ramesh and Ashish, last bit before we have 5 minutes or 10 minutes of time for Q&A as well.
Yeah, so just as a food for thought at a very high level, essentially, as a disputes lawyer, we come across a lot of these, as a disputes lawyer in Delhi and even I'm sure in Madras and other high courts as well, you come across a lot of litigations where the IP owners are enforcing their rights against an errant party and alleged wrongdoer. For example, a domain name, a trademark being used as part of a domain name, and there is a website there. The website is then potentially being used to lure customers. The customers are misled into believing that there is some brand association. So essentially, what is happening in a lot of these cases is the actual wrongdoer, what we call as John Doe suits essentially, the actual wrongdoer is not an identified individual. So the idea is that the service provider, which is in case of a domain name, for example, a domain name registrar, like a registrar providing services of registration with whom you register a domain name, is made a party in these litigations, and then the information relating to this alleged doer is sought from that service provider. So where the clash happens, again, I mean, being on both sides of the divide in a practical sense, it's more of a food for thought, and the actual challenges which we come across in practicing, and in seeing the intersection of IP enforcement with data protection. A lot of the time, the wrongs are egregious. So what do I mean by that? There is a large-scale fraud happening. You know there is a wrong happening. So a lot of the service providers may have a privacy protect feature. What that essentially means is when I am registering a domain with a domain name registrar, I can avail of a feature which hides or masks my personal information. Now the basis for that is internationally, you look at GDPR, you look at the international privacy guidelines and the norms, there is basis to, there is a legitimate basis because you find the basis for that in privacy frameworks across the world. So these service providers are operating around the world. So then the idea is the brand owners seek a direction where they want that information from the service provider. So in these circumstances, of course, then if a court passes a direction, the service provider will obviously, he's operating in India and they will follow follow the law of the land. Now the question is, which is the brand owner's perspective, is why do we need to constantly go to court to seek this information? Shouldn't the policies of these service providers factor in cases of egregious violation and provide this information without going to court? Whereas the service providers, their perspective essentially is they are operating businesses across the world. So the privacy laws are varying from country to country. So they are following a minimum standard of privacy in terms of the established privacy principles. So they don't want to be in a situation where for one country they create an exception that I will do it without a court order. If there is basis, if this is the system they are following internationally, they want to follow that system. So there you have both sides of the spectrum where the IP owners, the brand owners have one perspective, and the service providers, your platforms, it could be a domain name registrar, it could be a social media platform. They say that there is a court order requirement. Now, how does DPDP deal with it? So DPDP, in a sense, provides the court order as a legitimate use for processing personal data. So, in a sense, this has been the practice. The DPDP legitimizes that practice by saying that if there is a court order, you are permitted to process it. So that's essentially not resolving the sort of nuanced conflict between the two, but recognizing the established practice. So this is one food for thought which both sides will have to probably collaboratively evaluate and see if they can look at a framework where they identify certain kinds of violations, where potentially you may have to look at a framework outside the courts and a framework where this data can be disclosed, but keeping the safeguards of privacy in mind. So that's just a food for thought.
Thanks, Vihan. At least 2022 e-commerce rules amendments, if you have already followed, has actually brought in certain amendments and suggestions that the retailers listed on the e-commerce can be compelled to be giving their actual identity. So they have to give their PAN card, their Aadhaar, e-Aadhaar or commercial Aadhaar, so that if infringing articles are found on e-commerce. So similarly, I think the registrar rules of GoDaddies and other registrars can be changed for overcoming the privacy guidelines. So over to you, and Ashish and Ramesh, if you had last few thoughts on what you believe the future is going to be of enforcement or implementation of data protection.
I think there are two fundamentals to this. It's like any IP owner. One is you protect it, and then you kind of make sure that doesn't get violated. So in this case, what I feel is that in terms of data is that the first part would be obviously to safeguard internally as to how you make sure that whatever comes in is processed properly, is in compliance with the regulatory requirements, and doesn't get leaked out. So obviously the auditing, assessment, data impact assessment, whatever you may call it, but that's something that one needs to do. And I'm sure going forward there would be some kind of a quarterly report or an annual report that one may need to share, because there is a requirement that if there's any breach that has to be intimated by to the meeting. Now the question here is that that's one part. That is something that you do within your vicinity, within your control, because you can, in a way, adopt, implement or apply any kind of software or anything to get that in control. So I think first is make your house in order. The second part is obviously, yes, some things which Vihan has already spoken about is taking action and making sure that things are there. But I guess these are the twofold I see it. And going forward, I think it becomes very important that there has, like for instance, if I speak in the trademark sense, there is a monitoring system for any similar marks that are there. So maybe there will come a time where there'll be some software in the market which kind of, if you put it, it will show that, oh, something is leaking, or some kind of an alert will come. So there'll be that kind of a business that may even erupt at one point in time, because the deterrence factor or the penalties would be so high that everyone will be very cautious about it and will definitely, kind of apply to it.
In the aspect of the enforcement aspect, as Nihan pointed out, especially we had the same issue with the digital copyright issues as well. So when it comes to the enforcement part, the role of intermediary like ISPs are very important, but the laws are not so strict on the ISPs, because it says that whenever it's been flagged to the ISP and they just figured it out, there is no strict measures taken on the ISPs. Now, if you see even the current Act, DPDP Act 2023, from the old Act, there was a DPA, Data Protection Authority, and now there is a significant data fiduciary, SDF. And there are procedure to set up a mechanism and grievance redressal mechanism, but I don't know how far it's going to be very strict. And whenever there is for example, when you collect the data for a particular purpose, if it is being used for a different purpose by a different third party, and who is going to monitor if there is a breach? I don't know whether the new act and rules will address those issues. So that will be the very challenging thing. And when you obtain a consent, as the Puja said, you obtain a consent because there is a new person, the new body called consent manager, as you said. So they may monitor, but there are issues that I give consent for a particular reason, but when that particular purpose is over, whether these data will be misused for a different purpose or a different company. So what happens to that consent for a different purpose? That is a question that still remains. Especially the recent issues, if you see, there are many mobile apps that gives loans. They are not regulated. See, I go to ICICI bank or some bank, I give my personal data and financial data to obtain a loan. But those data are being shared with other companies which are not even regulated by financial RBI or whatever it is. So those data are being misused by these apps. So what is the role of this ISP? For example, you cannot simply download an app. There is a Apple Store or Play Store. So what is the role of these intermediaries when there is a misuse of my personal data and financial data? So these are the million-dollar questions. I don't know whether the new act and rule will answer this.
One thing I wanted to also add, because that when he mentioned it, it just came to mind, was when you actually, like a company is actually getting data. Now sometimes it outsources that data for whatever purpose, analysis or whatever. It also becomes very important that the agreement which is between that outsourcing entity is very robust so that you don't violate anything, including how it's entered, how it's used, how it's processed, and how after everything is over, how it's deleted and given back, to ensure that they don't have any residue element of it. So I think it's very important that people understand that data comes in, but they have to also understand that one day you are allowed to keep it only for a certain period, or to erase it if it's not required anymore. Because your purpose of what you've used it is finished. So that's something also when people prepare contracts and agreements, these are the minute clauses that one needs to keep in mind.
So I'll just have one last question, possibly to Puja, and asking her, yes, we are talking about consent, we are talking about purpose, we are talking about repurposing, we are talking about misuse. Are there any exceptions to the consent rule under the statute, and when do you think these are going to be kicking in?
Bharath, like you said, we have discussed a lot of aspects, but we have not discussed that to who all this does not apply. So, most certainly government, while framing these, this DPDP Act, has kept certain areas outside the purview of taking consent. And as far as all our Aadhaar data is concerned, that repository is completely outside the purview of consent. And another interesting aspect is that, see, DPDP Act is being introduced at a certain point, right? In a certain point in time. A lot of data is already available with government. A lot of government departments, authorities have certain data with them. So if it is prior to the date of this act coming in, that data will continue to remain with them. It is not that that data is going to get wiped out in any manner. Another important thing is that this data, whichever is available as per Aadhaar or through any of these agencies, can be used at the time of any kind of natural disaster or any kind of health-related, say, COVID vaccination or any similar activities which are for the general good. So for all such purposes, I mean, there may be more categories which are outlined by the government as and when the rules come out. We are always harping upon the same fact, but then as of now, these are broad categories which have been kept outside the purview and they fall under the exception to the rules.
Thanks, Puja. Yeah, we'll come to the questions. I just wanted to summarize and just say that there are newer roles. We as lawyers have been very binary. In the sense, are you in-house, are you external counsel? I see that in data protection, these are kind of getting merged. I see more and more law firms hiring in-house counsels into law firms which are, who are data protection officers. And then there are newer roles which I've just noted down, CISO, Chief Information Security Officer, there is Chief Privacy Officer, there is Chief Data Officer, there is Chief Technology Officer. So data protection is no longer just pure legal, it's going to be techno-legal. Last but not the least is that there is a lot of work for all of us. Right? For external counsels or law firms or in-house counsels, it is going to be a lot of work. Ma'am, we will give your time at 1:40. We have 2 minutes for questions. I have 2 hands up. So if you can give one mic to the 2 gentlemen whose hands are up, Abhay and the other younger gentleman.
I can just raise it to all of you. How does it apply to lawyers and the law firms and their regular law firm practices? This law.
So, Puja.
That's what I was saying. We could have discussed this within our law firm.
Partners meeting mein pooch lo yaar.
But nonetheless, since you have asked it, first and foremost, as a law firm, definitely, and in an IP space, we are handling a lot of data which has to be protected, and the client who is sharing it with us is sharing it with the confidentiality aspects in mind. So even if DPDP was not there, as a law firm, we have been adhering to all the confidentiality aspects as far as whatever data is shared with the law firm by the client. And as far as courts are concerned, definitely we still need to see how it gets implemented. That aspect, that what is being uploaded, like Ramesh said, that whatever is being uploaded on the websites of the different registries or of the different offices, to what extent some details are getting disclosed, that aspect will have to be seen in the light of the rules.
Yeah.
I just want to, it was interesting you asked this because in Jan 4th I see this, there's this article which says the law firm that handles data breaches was hit by data breach. And it was actually, I'm not naming the firm, but actually they lost around 637,000 data breach victims.
That person needs a raise. The lawyer was not given a raise who was the data breach person.
No, he wasn't.
On a serious note, so the other gentleman, please, and then to you, ma'am, last question. Because 1:40 is lunch, and we are at 1:40. We are in time, but gentleman had his hand up first. Yeah.
Hi, so I'm Karthikeya, I'm from Sai Krishna. So my question is not related to IP, but because the industries are getting connected, so my question is like, for example, everyone wears a smartwatch. We have our health data there, and iPhone has this technology called crash detection. So don't you think the DPDP Act will become frivolous or moot in the near future, where you've given certain purposes, certain intentions, and your consent, valid consent to these fiduciaries, and where your data is being diverted from either one service person to the other? Don't you think that because your purpose is changing from day to day and from your data is just being, so what are your thoughts on that?
So I would like to point out that the entire basis of this act is, like I said, consent. If you are buying an Apple Watch and wearing it to record your parameters and kind of create a history of how your heartbeat is going, or whatever your vital statistics are, or how much running you are doing. So in a way, you have signed up for that service and creation of that database, right? Otherwise, you will not buy that watch in the first place. So if your consent, as of now, till the act is not there, your implied consent is there by using that particular product, which you are aware captures so much of your personal data. So having said that, I mean, if consent part is taken care of, then saying that this act is being nullified is a little far-fetched. If say you have already not been using that and you begin to use it after this act and the rules come into force, and they do not ask for consent in a formal manner, then perhaps this question can come. But right now, everybody who is using it knowingly.
Yeah, just a follow-up to that is basically when your health data is being used, say by Tesla, because Tesla uses it for insurance, where you have autonomous vehicles, where your insurance is linked to how you drive and how much you drive, whether you're braking hard or not. And for example, if there's an accident, so that's linked to an ambulance. For example, I'm just creating a hypothetical for the sake of it. So when that health data might be linked to an ambulance, where your blood group, or whether you are a blood pressure patient, that whole process where you have kind of given us consent to, say, Tesla for your driving purpose, and where you have given your healthcare data to Apple, and there's a, say, an agreement between a healthcare and an...
It's about, I got your question. It's about misuse. See, as Puja said, when they collect, Apple Watch has your health data and personal data. See, as long as you are giving consent that it is used for your purpose, it's okay. But if they secure the data and share it with somebody who is unauthorized, then there is a data breach. Definitely, they can take an action, like what happened in Facebook cases. In 2016, you know, they, at least 50, 60 millions of people have, the data are being stolen, and they have used it for a different purpose. And we all know the story that Facebook has to pay the fine. So when you collect the data and use it for your purpose, as she said, you have given the consent for a particular purpose. But when it is being used for a different purpose without your consent, that is where the data breach happens, and definitely they are liable.
So we will take further questions offline. But one last question to this ma'am here. But to answer your question, it's repurposing which is bad. You need to have consent for a new purpose, or repurposing or up-purposing. Yes, ma'am.
So first of all, thank you for a very interesting panel, and also thanks to the moderator for putting it all in perspective. I just had a quick question. In the context of the AI and the chat GPT, how do you see the DPDP Act coming up, and what do you think are going to be the challenges? How do we see the whole process evolving?
So I'll quickly answer that so that we wrap up the session. I see metal clanking out on the plates there. So what happens is ChatGPT will throw back what you put in. It's up to you to put in whether you want to put in your personal data there or not. So you can say, I'm Bharath male, or I would say, I'm sorry, I'm Bharath male, 40 plus, O positive, please write a story on me. I've already given my personal data into the ChatGPT. So it's up to you what you feed in to get back what you want. If you put in personal data, to go back to the question which Abhay was asking about law firms, not all data are under the DPDP Act. So there are 3 or 2 prefixes to the data. It's personal data, it's digital personal data. Not all data, not all personal data, but only digitized personal data. So it can be in physical form, it's not DPDPA. It can be digital form, if it's not personal, it's not DPDPA. So commercial data, data relating to commerce or entities is not DPDPA Act subject matter. So we will take it offline because there is, I can smell food, I can hear food being eaten. So we are a full wrap, but great kudos, thanks to all the speakers to keeping it under the time limit. We are only 6 minutes late, but thank you for a wonderful audience.
Thank you so much, sir. Concluding this session with gratitude for the engaging dialogue indeed, and may the shared insights resonate in your professional journeys as well. Thank you so much. Gratitude to our panelists for their invaluable contributions that enriched the depth of this enlightening discussion, and of course to our moderator for steering really the ship of this discussion. Your guidance really has led to a very rich and a very engaging session. I'd present mementos. I'd request Mr. Abhay Pandey to please present mementos. I'd request Mr. Abhay Pandey to please come forward on stage. Sir. I'd request sir to now present first memento to Mr. M.S. Bharath, the moderator for this session. Thank you so much, sir. And also to the speakers, Mr. Ashish Chang. Thank you, sir. Ms. Puja Tiwari. Mr. Ramesh Ganapati. And Mr. Vihan Dang. So thank you so much, gentlemen and the lady, and to all of you for joining us in this session. I request you to please go forward and go have your lunch. We'd be reassembling in 1 hour time for the quiz session that is scheduled at 2:40 p.m. Thank you so much.